During the audience Q&A portion of the conversation with Justice Souter that opened this program, he was asked what he thought about the Supreme Court having women and racial minorities as part of its membership. And he said a number of really thoughtful things, but at the end he summed up by exclaiming, "God bless diversity on the Supreme Court." What a wonderful thing to hear from a Supreme Court justice. And so diversity is the topic that I want to talk about today. Not so much on the Supreme Court, but really more in the context of higher education and more generally. So what I want to do is to address what I think of as a hard question about the value of diversity as it relates to the constitutional value of equality. Clearly, people like Justice Souter who value diversity care about equality, right? And people who care about diversity will often tell you that we care about diversity because we care about equality. But here's the problem. As history has shown, right, within certain populations, diversity isn't something that just happens, right? It doesn't just fall out of the sky. The reality seems to be that sometimes in order for a community to become diverse, for example, a community in a selective university student body, in order for a community to become diverse, certain affirmative measures have to be taken. For example, you might have to give certain underrepresented populations a little bit of a boost, a little bit of a leg up, maybe even a little bit of a preference in admissions, right, in order to make diversity happen. But now this seems a little paradoxical, right, because giving someone a preference or a leg up, right, seems like the opposite of equality of treatment, right, or at least that's one way to think about it. So the hard question is this: is it consistent with the constitutional value of equality to give some people a preference in order to make a particular community more diverse? How does the Constitution's mandate of equality really leave any room for that kind of thinking? How does the Constitution's mandate of equal treatment leave any room for contemporary arguments in favor of promoting diversity? Doesn't equality mean that the law has to be colorblind? I mean, isn't our Constitution supposed to be colorblind? Isn't it supposed to be the case that characteristics like race and ethnicity and background shouldn't count for anything? Well, I'm not going to try to resolve that question this morning, but the main idea that I want to present to you today is that, because the concept of equal protection of the laws, right, that's the term in the Constitution, because the concept of equal protection of the laws is, while extraordinarily powerful, also inherently vague and inherently abstract, the Supreme Court's interpretation of what exactly that concept implies has really evolved and shifted along with changing social circumstances and prevailing norms in society, right? The competing values of racial diversity and colorblindness are both, I would say, those concepts are both manifestations of the Supreme Court's attempts at various points in its history to flesh out the meaning of this abstract concept of equal protection of the laws. So I want to start by looking at the historical origin of the idea of colorblindness, right? It goes back 1896, this case that was already mentioned, Plessy versus Ferguson, right? This case had to do with a law in Louisiana that required whites and blacks to ride in separate railway cars, right? That was the law of the land in Louisiana. The plaintiff was a man named Homer Plessy, who was denied entry into the white railway car because he was 1/8 black by ancestry, right? He was 1/8 black, but he was still considered black under the laws defining blackness in Louisiana. So he sues the railway, asserting that his constitutional right to equal protection under the laws was violated, right? So the question for the Supreme Court is, well, what exactly does equality mean here, right? It's true that blacks and whites are separated into these different railway cars, but why is that necessarily unequal? The Supreme Court thinks about this, and in an 8-1 decision, the court at that time, 1896, right, the court says putting blacks and whites in separate railway cars did not violate constitutional equality, right, as long as the facilities provided to both races are the same. Right, so the court, right, this is the famous separate but equal doctrine, right? The court rejects the argument that this sort of legalized segregation stamps the colored race with a badge of inferiority, which is what Plessy had argued. And the court says, if this be so, right, if there's a perception of a badge of inferiority, it is not by reason of anything found in the law, but solely because the colored race chooses to put that construction upon it. That's what the court says. So the court's saying here in 1896, racial classifications are okay. Right? There's nothing unequal about racial classifications as such, as long as each group gets the same thing. Right? Again, separate but equal is consistent with the Constitution. The famous dissent is written by Justice John Marshall Harlan in that case. Right? And Harlan's view as the lone dissenter is that the classification itself is wrong under the law. And his famous phrase is, our Constitution is colorblind and neither knows nor tolerates classes among citizens. And we've probably all heard that phrase before in one fashion or another. But let me quote you the whole paragraph where that phrase occurs, because I want to make a point about the social context of Harlan's notion of colorblindness. And if you've never heard this before, the first part of this paragraph is going to surprise, maybe even shock you. So let me start here with the first paragraph, and then you'll see the context of this colorblindness quote. So here's Justice Harlan. The white race deems itself to be the dominant race in this country, and so it is. And so it is in prestige, in achievements, in education, in wealth, and in power. So I doubt not it will continue to be for all time if it remains true to its great heritage and holds fast to the principles of constitutional liberty. But in the view of the Constitution, in the eye of the law, there is in this country no superior dominant ruling class of citizens. And here's finally where his famous phrase comes in. Our Constitution is colorblind and neither knows nor tolerates classes among citizens. In respect of civil rights, all citizens are equal before the law. The humblest is the peer of the most powerful. The law regards man as man and takes no account of his color when his civil rights are guaranteed by the supreme law of the land. So this is at once, powerfully eloquent, right? Under our colorblind Constitution, the humblest is the peer of the most powerful. And at the same time, deeply disturbing, right? There's obviously a deep-seated, old-fashioned racism in Harlan's comment here, right? That the white race will continue to be undoubtedly the dominant race for all time, right? And Harlan himself came from a slaveholding family and had earlier in his career, defended slavery against abolition. So maybe it's no surprise. But I don't want to defend any of that, nor do I condone the things that Harlan says elsewhere in his dissent about the Chinese race, but which are even more shocking than what I just read to you. But I do want to observe that it's important to see the point about equality that Harlan is trying to make here. For Harlan, colorblindness is a rejection of legalized segregation, right? That's where he's coming from. For Harlan, colorblindness is a rejection of legalized segregation, right? It's a rejection of the Jim Crow laws, which the southern states had been using as a way to maintain white supremacy and privilege after the end of slavery. Harlan criticizes the majority, right? Harlan criticized this idea of separate but equal for ignoring the social significance of these legal segregation laws, right? He asks, and again, I'm reading from his dissent, what can more certainly arouse race hate and perpetuate a feeling of distrust between these races than state enactments which, in fact, proceed on the ground that colored citizens are so inferior and degraded that they cannot be allowed to sit in public coaches occupied by white citizens? That, as all will admit, is the real meaning of such legislation. Right? So while we may be put off by Harlan's remarks about the social fact of white dominance, right, he's really trying to be more aspirational when it comes to the law. Colorblindness in this Jim Crow era is a way of colorblindness for Harlan, right, is a way of rejecting the laws that marked blacks as a second-class set of citizens, a rejection of the legal subordination of minorities. That's where colorblindness, this idea, started. So remember that when I circle back to the meaning of colorblindness in the context of today's debates about affirmative action. So let me move forward then to another case that was mentioned already, Brown versus Board of Education, where the Supreme Court's concerns about racial classification, right, the idea that Harlan was talking about, as a means of subordination, right, in a way that contradicts equality, reach a famous culmination. So Brown v. Board is, of course, the famous school desegregation case that overturned the separate but equal principle announced in Plessy, and here in Brown v. Board, Harlan is largely vindicated. And like Harlan, in answering the question of what equality in public education means, the court looks to social context again, the contemporary state of society. And in fact, the court explicitly says, in approaching this problem, we cannot turn the clock back to 1868 when the 14th Amendment was adopted, or even to 1896 when Plessy v. Ferguson was written. The court says, we must consider public education in the light of its full development and its present place in American life throughout the nation. And considering the centrality of education in our society, right, and the actual social meanings of racial segregation, the court concludes separate educational facilities are inherently unequal. In other words, the very act of classifying school children by race is an act of inequality. Right? And then the court adds, separation of this kind generates a feeling of inferiority, right, as to the status of blacks in the community that may affect their hearts and minds in a way that is unlikely ever to be undone. Right? It does irreparable damage to the hearts and minds of our young school children. So in Brown, the court comes all the way around, really, to Harlan's point of view. It says the court interprets constitutional equality to prohibit the use of racial classifications to determine which school a child can attend, because it's both inherently unequal, right, and because as a social reality, it subordinates blacks to a position of inferiority. All right, so that's 1954 Brown v. Board. What happened after Brown? Well, a lot happened. Of course, it was a long, hard struggle to implement the desegregation that was ordered by Brown. And then in the midst of that struggle, importantly, right, 1964, Civil Rights Act is passed. And throughout the 1970s, the courts were busy implementing all these new legislations in the many litigations that the Civil Rights Act spawned. And so to be sure, all these developments allowed for many opportunities to open up for minorities that had never been available before, right, that minorities would never have even sniffed before. Whites and blacks were going to the same schools, and in theory, the same jobs were supposed to be there for them when they entered the workforce. But at the same time, right, the reality was not quite so bright, right? There was a big big gap between theory, right, the formal equality of opportunity, and actual results. Right? For minorities, it was obvious that real measurable progress in achieving substantive economic equality was very, very slow to come. So it became clear that the requirement of just not excluding minorities from jobs and valuable opportunities was not going to be enough, really, to get us all the way to equality. Right? In order to make that sort of progress, it seemed to many people that affirmative action would be needed. And so a new set of conflicts began over the meaning of equality. In the words of Martin Luther King Jr., quoted in an article by Reva Siegel, a law professor at Yale Law School, here's what I take to be a very insightful comment. So, responding to the general idea that equality means erasing racial classifications but not giving preferential treatment, Martin Luther King says, on the surface, this appears reasonable, but it is not realistic. For it is obvious that if a man is entering the starting line in a race 300 years after another man, the first would have to perform some impossible feat in order to catch up with his fellow runner. Martin Luther King. Zoom ahead 40 years from that time, 1964 to 2003, when we as a nation were still struggling with racial inequality as a fact of life in this country. By then, many public universities, perhaps feeling that maybe they had an important role to play in helping to alleviate this problem, many universities had implemented affirmative action in their admissions policies, right? They gave preferential treatment to minority applicants. The theory was that by creating a racially diverse student body in these elite educational institutions, right, we might be giving a benefit not only to the minority students who were admitted under the preference, but we might actually be giving all the students in the university a better educational experience that might redound to the benefit of society when they entered the world. So the problem, of course, right, is when you're talking about a selective institution, for every extra student that you decide to admit, that leaves one less seat in the class for everybody else, right? So there's a student a white woman who applied to the University of Michigan Law School who gets rejected, and she complains that, I'm just as good as some of the minority, or better than some of the minority students who were admitted with a preference. So she sues Michigan, and the case ends up going to the Supreme Court. And now the court says in a 5-4 decision written by Justice O'Connor and joined by Justice Souter, the court says, it's true that in general, racial classifications have to be scrutinized very strictly, right? There's always a danger that racial classifications can be used to subordinate a group that's in a minority position. But, the court says, in the context of higher education, the constitutional concept of equality allows giving a slight preference to racial minorities in the admissions process. Why? How is this possible? The answer, again, lies in the relevant social context, the relevant social facts. Our institutions of higher education play a critical role, right, in preparing our youth to be the leaders, teachers, employers, public citizens of tomorrow. So then the question is, if a university cares about social equality, how can it best make sure that its students will go out into the world with a set of attitudes and beliefs and perspectives that will contribute to greater racial equality in our society? Well, clearly, one thing that would seem to make a lot of sense is if the university would see to it that students are having their formative intellectual experiences in a racially diverse community of learning, right? Because in a racially diverse community, as the Supreme Court, as Justice O'Connor says in her opinion, cross-racial understanding is maximized, racial stereotypes are broken down, right? Diversity in the student body helps students internalize the values of equality that they will need, right, once they get out into the world and become effective, responsible citizens in a racially heterogeneous society. So even though the court had said in the past that racial classifications are always suspect, the court says that in the context of higher education, it's permissible for the university to use racial preference to create racial diversity, because in this particular social context, right, the long-run benefit will be, hopefully, to reduce levels of racial inequality and subordination that continue to exist in our society. Well, of course, as you know, affirmative action in university admissions has remained a very controversial topic even after Grutter, and it will be revisited by the Supreme Court this term in the case of Fisher versus University of Texas, which will likely be decided by next June. So I'm not going to detail the case here. Maybe we can talk about it in Q&A. But suffice to say that this case, again, implicates the conflicting values of racial diversity on the one hand and the idea of colorblindness on the other. So some argue that racial diversity continues to be a compelling interest, right, in the context of higher education that justifies the limited use of racial preferences. The argument on the other side, right, that we're all familiar with, seeks a return to colorblindness, right? Harlan's principle, right, in his dissent in Plessy versus Ferguson. Again, I'm not going to try to resolve the conflict. I will close with a couple of observations. First, the story of how diversity serves the value of constitutional equality is one that's highly dependent on social context. Right? Using preferences to create diversity in the name of equality really only makes sense when we are attentive to the context of higher education, right? the idea of giving a preference to create equality only makes sense when we think about the mission of higher education and the social effects of putting certain groups of people in a selective educational context. Outside of those, specific factual points of context, the idea of using race preferences in the name of equality will seem, paradoxical or irrational. But, the thing that people don't focus on so much is that colorblindness, too, is kind of an odd thing to champion, right? So, after all, colorblindness, that's a defect of vision. Colorblindness is an inability to see something in the world that's really there, right? Now, it really only makes sense when we remind ourselves of Harlan's historical context. For him, colorblindness was a sort of filter that he wanted to place on the lens of the law during a time when white supremacy was the dominant mode of cultural vision, right? Colorblindness was a way to kind of prevent the glare of white supremacy. Colorblindness was for Harlan a repudiation of racial subordination. Well, let me ask, does it still make sense to impose Harlan's colorblindness on the law today when the law is trying to take a far-sighted approach to reducing problems of racial subordination and equality? I don't know. But as I hope you can see, the idea of colorblindness in the social context of higher education today, I think, has a much different set of resonances than the idea of colorblindness in the time of Jim Crow. One can argue that was once an aspirational principle, right, for Harlan. An aspirational principle of constitutional interpretation has become, at least some would argue, an impediment to percipient solutions to evolving problems of racial inequality. Thanks.